Good morning and welcome to the Appeals Court. I am Chief Justice Amy. What is going on? Is this your client?
Yes.
He sits not in the bar. Okay, let's start again. I am Chief Justice Amy Blake. To my right is Justice Suk-Young Shin. To my left is Justice Chauncey Wood. We are your panel for today's cases. The reason that it is 10:05 and we had not been in the session is our first case of the morning was heard on a video conferencing platform, so we have been hard at work, just not in the courtroom. Go over a couple of ground rules. Each side is permitted 15 minutes of argument. There is no rebuttal. I can assure you that we have read everything, so you should get right to your arguments. I will say each of the cases today that are on the list have some level of impoundment, so I ask counsel to be mindful and to please comply with the rules of impoundment. You should also note that our video cameras do record, and we are posting and streaming live on our YouTube channel, so there are some signs in the courtroom. If you do not want to be on camera by accident, you should pay attention to where you're sitting. Essentially, the seats in the middle can get picked up by our cameras. That's particularly important on the DCF case because that is a fully impounded case, and we do not want any of the parties, if they're in the courtroom, to be seen. Just a reminder, clients are not permitted to sit at counsel table in the appeals court. With that, I will call our first case of the day, second case, I should say, first case in the courtroom, Commonwealth versus Ira W. Proctor III, docket number 24P1127. This case is partially impounded. Attorney Kaminsky, when you're ready.
Good morning, Chief Justice Blake and the rest of the panel. This is a simple case. Swaddling your infant son to feed him the same way you had your daughters before him is not reckless. I mean, that is the key fact in this case. Ira Proctor was simply feeding his son the same way he had fed his daughters, holding him, and his son slipped, and he tried to hold on to him, causing a broken arm. I would submit this case is exactly like, Commonwealth v. Hardy, where the defendant used a front-facing booster seat, and, the child she was transporting suffered some injuries. In that case, the defendant was using, the incorrect booster seat the same way she had before with her own son. And, maybe that, if you took every inference in favor of the Commonwealth, maybe that's negligent. But for the crime charge, it wasn't reckless. And that's the heart of the sufficiency argument, that because Mr. Proctor was feeding his son exactly as he had done before, and no one had told him, the way he was doing that was wrong. I mean, he says that's how they showed him to do it at the hospital. That's how he had done it before with his daughters for years. And no one said anything was wrong with that. In fact, even after these injuries, his pediatrician said to him, you need to hold them differently because they're getting older and they're getting more mobile. You need to worry about that now.
Well, could the judge have found that that's not how the injury happened?
Based on the evidence presented, I don't think so. There was no testimony, no argument that anything else had happened here with the arm injury.
Well, weren't there some medical professionals who testified that the injury and the amount of force it would have taken to cause this injury is not consistent with your client's version of events? So could the judge not have believed those witnesses?
So even looking at Dr. Swartz, the Commonwealth's, child abuse expert doctor, she conceded, these injuries the arm injuries could have occurred exactly as Mr. Proctor.
She did, but weren't there other medical professionals who testified otherwise?
Certainly there were there was other testimony as to the amount of force, and, they believed that these sort of injuries, they didn't correspond with Mr. Proctor's story. They would have required more force. And, that gets into all the facts provided by the defense's witnesses. These were premature infants. There were twins. There was, vitamin D deficiency with the mother. And all of these things meant that, their bones would have been a little bit weaker, and the injury suffered, therefore, a little greater from
I thought the
whatever
blood work
force
showed
was
that there
applied.
wasn't a vitamin D deficiency to the child. I might be wrong, but
So
my memory.
the best way to explain this is like if you go to the gym and work out. Like the first time you go, maybe you can't lift that much weight or run that much. Your bones they adapt over time, your bones and your muscles. So these were 3-month-old infants. Their mother, while she was carrying them, was vitamin D deficient. They tested her, after these injuries, she was still vitamin D deficient. And so, during the gestation period, the babies, their bones would have been a little bit weaker, especially because they were twins and there was that vitamin D deficiency. So you have two babies competing for, less than the amount of vitamin D they needed for full bone strength.
You've challenged sufficiency, and I appreciate your argument, and I understand the argument below was there was an innocent explanation for this, but aren't we required to look at this in the light most favorable to the Commonwealth? And how do we get around, if you agree with me that that's our standard? We have, I think it's the Robinson case, it's a kind of a recent case in 2023 that talks about a judge or a jury's, the fact finder's ability to reject one expert over another expert. Can you help me with that?
Certainly. So in this case, what I think the difference is, the fact that matters in this case, is that, Mr. Proctor was doing something he had been doing for years, feeding his daughters the same exact way. So when he's doing that action, the judge agreed with this. He had no idea that was reckless. None. And I would submit that a reasonable person would not find it reckless either. I mean, this is just like other cases where, like use the wrong car seat, or perhaps a caregiver gets up to go to the bathroom and they're gone for 5 minutes. These are everyday
So what's your closest
things.
case on recklessness to this case?
I would submit Hardy is the closest case.
Hardy?
Correct.
Following up on this, well, Dr. Stoller, the Commonwealth's expert, expressed an opinion that fractures are not a part of hypermobile EDS, and there's no connection between EDS and the unexplained bruising and fractured bones. I take that to mean that there was a factual dispute between the experts on either side, and that this, in other words, the Commonwealth's point is that this injury cannot be explained by EDS or a vitamin D deficiency. But that's the Commonwealth's point, right? Or that's their argument. Well, I'll leave it to them to characterize it. But if I've got that right, then it seems like this is a factual dispute that the judge, in other words, the judge is certainly free as the fact finder to reject this argument that it was in any way a product of a vitamin D deficiency or anything else, any other genetic predisposition, right?
The defendant would submit that as to the arm injury, the only evidence presented was Mr. Proctor's statement, and none of the experts, none of the people who spoke with them rejected that.
Right, but sorry.
Whether their
I just
experts
but wait,
labeled that.
So hold on, I just want to make sure, but there's a ton of testimony about the relevance of the genetic predisposition and or abnormality and or vitamin D deficiency. All of that, the relevance of all of that is that could have contributed to the broken arm as well as the ribs, right?
Certainly, but the defendant.
Okay, so my point is, I'm struggling to understand is, there's a legitimate factual dispute, and the Commonwealth is saying none of that was relevant here. And why is it relevant?
I would argue that the relevance, it goes to the weight of the evidence and how to understand it. But the reason it's relevant is when Mr. Proctor knows this. So he knows all these things after the accident happens. So him or a reasonable person, they don't know anything about all of these.
When you say these things, sorry, you can help me. What
this
things?
injury, the arm injury.
Yeah.
So when this happens, Mr. Proctor's feeding his kids the way he has before. just like anyone else would. And, you know, all the diagnosis with the earlier Danlu symptoms and, you know, the bone weakness and the vitamin D deficiency, that all comes later. So I would argue just for the sufficiency, we don't get into weighing, you know, all of these facts. It's a simple question of what he knew, you know, when he was feeding his son and that arm break occurred. And
Can I ask you just a question on a different issue, which is the docket? Do I understand correctly that the actual docket reflects the misdemeanor, not the felony? It's the electronic docket?
correct. And the defendant only brought,
I mean, the Commonwealth's not necessarily opposed to it, but how does that get fixed, as mechanically speaking? How do we do that on appeal? Isn't that something for the lower court?
the appeals court can do it, or
How?
the trial court can do it.
We do.
They're just directed to correct the electronic docket. And that only matters because it affects, you know, the defendant's query.
It affects what?
The defendant's query, so his record.
Is that an order to the trial court or to the clerk of the lower court? Is that to the Board of Probation? Who?
It's usually an order to.
Seems like something the two of you could fix really easily, as opposed to 3 appeals court judges that don't know how to do it.
Correct.
I mean, help me with it. If it needs to be fixed, we want to fix it, but we don't know how. I don't know how to do it. So tell me what we're supposed to do.
My understanding is if the trial court's directed to fix it and they enter that on the docket, everything will be updated, and that's it.
Okay.
I'm not sure beyond that.
Do you want to address the second issue, the permitting?
Certainly. Once again, this is perhaps more simple, like more of a simple issue than the briefs make it. Mr. Proctor was charged with permitting, so that's 13J, 4th paragraph. And the proof presented in this case was simply, you know, there was contact and an injury, and that's a battery. That's not permitting. And, you know, the elements are different on that. He wasn't charged with the battery, he was charged with permitting. And
Is permitting an assault and battery causing bodily injury a lesser included offense of what he was originally charged with, which was permanent bodily injury? That's the
Yes,
Commonwealth's argument at page 25 of their brief. So what is your response to that, that what he was convicted of was a lesser included of what he had been charged with, and therefore it's not a question that he was convicted of a crime he wasn't charged with?
I would offer that they're confusing the difference between permitting by a reckless act or permitting a battery by someone else with a lesser included argument. The argument the defendant is making is basically that he was charged with permitting, and the proof presented at trial and the judge's findings show that the conviction was based on Mr. Proctor having custody of the child and injury. There was no, essentially the proof amounted to battery, which would have been
Amounted to
a
what?
different charge. Battery,
Battery.
under the, you know, 2nd paragraph, 13J. And that's not what he was charged with. The complaint clearly says permitting, and the proof required for that is different. I'd point out, you know, the mens rea is different for permitting. There's, you know, either a reasonable person or Mr. Proctor, like the Commonwealth would have to show that they were reckless. With battery, you don't have to show that at all. The Commonwealth doesn't have to prove that, and that's the difference that matters to the defendant, because the Commonwealth proceeded under, you know, the permitting charge, so they didn't have to prove what happened. They didn't have to prove contact or anything else. They just had to prove that there was recklessness. And I would just point out again, you know, the judge's findings, it makes clear that the finding of guilty was based on Mr. Proctor having custody and the resulting injury. And the Commonwealth, you know, they bring that up again and argue it in their brief on page 22, that, you know, the injury proves recklessness. And the defendant submits that's not the case. you know, if they had charged this as a battery, there was no disagreement, there was contact, so an injury with contact would be enough, but they didn't charge it as that. They charged it as permitting, and that's not how they proved their case. One last fact I just wanted to point out where I disagreed with the Commonwealth. They said that there were no other fractures while the children were in DCF custody. Dr. Stoller, I know their expert just called it nursemaid's elbow, but looking at the record appendix at page 49, Charlie suffered a broken arm while she was in DCF custody. Lastly, I just wanted to say, you know, the court must look at the conduct that caused the harm, and that's very hard to do in, you know, a case like this where children are injured. But, you know, there was no conscious choice with knowledge of danger here, you know, just a man taking care of his kid as he had with his daughters.
I don't see any other questions from the panel, and you have a few brief seconds left on the clock if you have anything you want to say.
Seeing no questions from the panel, the defendant rests. Thank you.
Thank you very much, counsel. Attorney Kelly for the Commonwealth. When you're ready.
Good morning. May it please the court. Tracy Kelly for the Commonwealth. The evidence at the jury-waived trial consisted of the defendant's own statements as well as substantial medical testimony, which was sufficient to prove beyond a reasonable doubt that the defendant's conduct was reckless.
What's your best case on recklessness?
I think regarding this set of facts, I would point to both Commonwealth v. Garcia, 47 Mass. App Court 419. This case was similar in the way that they looked at, it was permitting another, but it did go through the recklessness, and it had a lot of testimony, medical testimony similar to this case, where there was an injury that had occurred that was not consistent with the defendant's recitation of events and required substantial force to have inflicted those injuries, and that substantial force showed that there had been reckless conduct.
Is this the one where the defendant in Garcia thought he was being careful, similar, or is that Hardy?
So Hardy, I'm not certain for the Garcia. The Garcia matter, there was.
I mean, the argument here, right, is that he thought he was doing all the right things. He had handled another child in that way. Essentially, this was pure accident if you disregard what he said the medical cause could have been. I thought Garcia was more like an accident type case, but I might have that wrong.
I don't believe so, because that was a case in which there were 30+ fractures on an infant, and there was a lot of medical testimony that showed these injuries could not have occurred without substantial force, specific mechanisms, which is what the Commonwealth demonstrated in this case as well. The medical experts.
Do you read the judge's? The judge explained his why he was finding the defendant guilty of this one charge, and do you read his explanation to be saying that he credited the defendant's version of events? It's not entirely clear to me, but that's how it reads at first.
I would not suggest that it is that clear-cut. I think that the judge's findings go through the elements of permitting and explain that he had care and custody of the child. The child was under 14. He suffered a bodily injury. The judge does discuss how this was not substantial bodily injury. He found it to just be bodily injury, that lesser included. And that then he states that he found the defendant's conduct, or the defendant was reckless in his conduct.
Right, and he says, it's not necessary for the Commonwealth to prove the defendant intended to hurt the child or that he foresaw the harm, but I think, unfortunately, that happened, And I'm sure if Mr. Proctor could replay the events, he would do things differently, but there's no escaping the fact that there was a bodily injury. That sounds to me like the judge is saying that he's crediting the defendant's story of how the injury happened, but because there was a bodily injury, he's going to find him guilty. Is that not how you read it?
That is not how I read it. I think that he's crediting that an injury occurred and that the defendant was responsible for it. I think based on the testament in front of the court, and as well as for this particular circumstance, we are looking at the evidence in the light most favorable to the Commonwealth, and there was substantial medical testimony that said this type of injury could not have occurred the way the defendant was describing it. It required...
We disregard the opinion of the Commonwealth's own expert that it could have occurred this way.
Dr. Schwartz did state that it was possible that the arm could have been broken this way. However, there was other doctors that testified that it was inconsistent with the defendant's recitation. Dr. Matthews, Dr. Conley, and Dr. O'Reilly all testified that this injury was inconsistent with the way that the defendant had described it. Additionally, Dr. Schwartz did state that taking all of the injuries, the unexplained bruising, the additional fractures, as well as the arm fracture, that she found in her medical opinion that there was child physical abuse here.
But that's not what he was convicted of.
He was convicted of the broken humerus.
Right, but I thought Dr. Schwartz said the arm injury was consistent with the defendant's version of events. The rib injuries were not, but he was not convicted based on the rib injury.
I believe that she took it into consideration and that it was a possibility. However, the Commonwealth did put forth additional testimony from medical experts that said this was inconsistent. I also believe that much of that testimony was discussing whether the rib and the fractured humerus could have been a single incident of permitting as opposed to separate occasions.
And usually when we see conflicting expert testimony, it's Commonwealth's expert versus the defendant's expert. And here you have the Commonwealth's own experts that seem to be disagreeing with each other.
I don't think that I think it still comports with the testimony, though. I think she took it into consideration, but that was not all that she relied on. It was a possibility, but there were additional factors at play, and other doctors did testify that this was not possible to have occurred in this way. Additionally, some of the testimony presented included a recorded interview of the defendant. He identified himself as the sole caregiver that evening, and he also acknowledged that he was responsible for the infant's broken humerus. The medical testimony overall showed that this injury is atypical for infants, 8-week-old infants, because they are non-ambulatory, and this fracture does not occur on its own. The doctors explained that substantial force is required to break a humerus bone, and that it is not something that an infant can do on its own. The force is so substantial and requires a specific twisting and jerking mechanism that was inconsistent with the defendant's recitation of events. The fact that it requires this much force and this kind of specific twisting jerking mechanism demonstrates that the defendant's conduct was reckless, because applying this degree of force and this mechanism to an 8-week-old infant is reckless. Additionally, Dr. Stoller, the clinical geneticist, ruled out the possibility that a medical condition could have contributed to this. The defendant talks a lot about vitamin D deficiency. However, the infant in this case was not vitamin D deficient. The results came back showing he was within normal range. The mother's vitamin D deficiency was taken months after the child's birth, as well as about a month after the incident occurred. So it requires a lot of inferences to be made that she was deficient at the time of childbirth, therefore the child was deficient in vitamin D, and the judge was not required to make those inferences. Additionally, genetic testing was done for various disorders, including osteogenesis imperfecta, which was negative. For Ehlers-Danlos syndrome, all but one type of EDS has genetic testing. This also came back negative. The child was evaluated, rather the baby was evaluated and looked at for hypermobile EDS. However, children under the age of 5 cannot be diagnosed with EDS. Dr. Stoller noted that the infant was a little hypermobile, but it was not hypermobile for a child of that age. Additionally,
Could I actually ask you, in the interest of time, to move on to the second issue, which is the permitting? I understand your argument that he was convicted of a lesser included offense to what he was charged with, but, and I understand that both parents were charged here and mom was acquitted, and so the permitting does confuse me because I could see the permitting as to the other parent. How is it permitting here if he's the one that's convicted of causing it?
so the statute has,
Doesn't it say permitting reckless?
the statute contains 2 clauses, and one is that whoever having care and custody of the child wantonly or recklessly permits substantial bodily injury, or bodily injury as is this case, or permits another to do so. It's not required that another person just does it. There's this.
So you're permitting yourself to do it? I don't, maybe my issue's with the legislature, but it's an odd construct, the statute.
I think that it makes a lot of sense, and the purpose of this statute was to protect children from violence and kids in caregiving settings.
Sure, but
So this
see what I'm
statute,
saying about permitting yourself, you're convicted of permitting yourself.
yeah, so it allows for a defendant to be charged both for acts of commission as well as acts of omission. So often it is in the situations of a failure to act. However, this is also shown often when there's a child left with a caregiver or an identified adult caregiver.
Right, but that's not this case. Stick to the facts of this case. The theory in this case, your theory in this case, is he permitted himself to injure the child.
Right, I think that still does apply here. He's left, and the infant is in the custody of the defendant, and there is an injury that occurred that is inconsistent with the explanation given by the caretaker and is not attributable to injuries or other medical conditions. Here, it was not an injury or an accident. This requires substantial force and a mechanism that is reckless to impose on an infant, an 8-week-old infant.
I'm struggling, I'm putting it in terms of notice. So I read the complaint, and it adds lots of different possibilities. But so and I'm looking at your brief at page 26, you're quoting of the statutory language. What's the statutory language that gives him, or the complaint, that gives him notice that the theory of prosecution that he has to defend against is that he's permitted himself to engage in a reckless act that injures the child?
Sure, so the plain language states, whoever permits bodily injury to such child. That is the language from the statute.
Okay. All right, and you don't think that there's a notice problem there? If I'm reading that, I'm thinking permits bodily injury, especially where my spouse is charged. I'm thinking what they're accusing me of is letting my spouse injure the child. You don't think that's a due process notice problem?
I do not. It does state that it could be, the or here indicates that it could be whoever, that could be the individual, the defendant, or the defendant, the same whoever applying to whoever permits another. So that same whoever can be the defendant doing it himself or the defendant permitting another to do so to the child.
We're talking about paragraph 4, right? Section 265, section 13JB.
Yes.
Paragraph 4. Whoever having care and custody of a child wantonly or recklessly permits substantial bodily injury to such child, or wantonly or recklessly permits another to commit an assault and battery. So I'm still, I assume that's where you're citing that language. The second part is clearly not at play here. It's the first part. Whoever having care or custody permits substantial bodily injury to such child. And I think on the facts of this case, you're saying the argument was he permitted himself to injure the child.
Yes, that is correct.
Was there a bill of particulars filed in this case?
There was, yes.
It was?
Specifically regarding the permitting aspect, this is this, not the definition of permitting exactly. However, there was a case in front of the SJC where the defendant was found guilty of her own conduct for under permitting.
What's the, sorry,
Commonwealth v. Chapman, 433 Massachusetts 481, a 2001 case. And the court in that case discusses, which is quite applicable here, that she was convicted not for her non-criminal conduct of putting the baby in the bathtub, but her act of putting the baby in the bathtub with this water in it that resulted in the death of the baby, as well as her failure to call 911. So the permitting statute can be just the defendant doing something, and leaving that, it creates this gap of opportunity for a caregiver to put the child in harm and without any sort of protection for those types of circumstances.
So you agree with Justice Wood that the second part of that paragraph is not in play, that permits another?
I would suggest that the defendant was convicted of permitting bodily injury on the child. The complaint, though, did charge him with both permitting.
But do you agree, based on the evidence at trial, that permitting another is not in play?
Excuse me.
I'm just trying to understand your theory of the case. So permitting another, based on the evidence at trial, is that still in play or not in play?
The Commonwealth went forward on both, on both theories. However, from the reading of the judge's finding, it does appear that he focused on permitting the injury as the defendant did the act himself. I also think that that was not in question. The defendant even stated in his interview that he caused this injury to the child. So the only thing at issue here is the reckless conduct.
I mean, I mean, to repeat what you just said, I'm echoing what you said, but that you relied heavily on his statement to the police, right? And, I think I screwed up, and your character.
I would suggest that that could be considered, but the medical testimony, so the defendant states that he was the caregiver that evening. There's no question that the child was only in his custody. Right. There's no dispute who caused this injury, but the medical testimony showed it was inconsistent with the defendant's testimony, right, and the force required was reckless, and a person applying that force to an 8-week-old infant would know that degree of force is reckless.
You're not accepting his version is accurate, but you're not disputing that he was the one who did it.
Correct.
Right.
Yes.
Okay.
Let me just see, because your time, Justice Shin has a question.
How does the electronic docket get corrected?
So I think that can be potentially just corrected by a conversation with the clerk's office, or I believe we could file.
I don't think it can.
Okay, I was going to say alternatively a motion to correct the record I think would be potentially appropriate.
Because it's on appeal, I think, I did look it up, I think Rule 42, I'm sorry I didn't do that before the argument. Because it's on appeal, we have to enter an order permitting the lower court to do it. So we'll figure that out, okay? But you don't disagree that the docket's correct, it's the electronic that's incorrect.
Excuse me, that is correct. The paper docket does reflect the misdemeanor. However, the electronic docket, the last time I checked, did not.
We'll enter our order, but you all need to run with that, okay?
Certainly.
We can't order it. We can just give permission for the court to order it.
Thank you. If there are no further questions.
Let me just check.
The Commonwealth
Very
rests
much.
on its brief. Thank you.
Very difficult case. Appreciate argument from both sides. The case is now under advisement. Thank you. Our next case is Commonwealth versus Santos A. Jimenez, docket number 25B 700. This case is partially impounded. Good morning, Mr. Benyon.
Good morning, Madam Chief Justice, and may it please the court. I'll go ahead and start with the second issue, if that's okay. This is bad act evidence. What I'd like to do is just draw the contrast between this idea at common law, where this was never allowed in, and today, where it seems to be brought in almost as a matter of course, and I'll get to the Seventh Circuit language. But essentially what occurred was on the 15th of July, because of the Commonwealth's motion that's in the record appendix, this material, and what we're talking about is the incident in the car is with respect to the pickle. There's an assault and battery, indecent assault and battery, and then this issue of oral sex. It's the issue of oral sex that came in later. It seems the young girl did not disclose this until up to the time of trial, and the government wanted to put this in. Usually what occurs, and you have the motion in front of you in the appendix, the government just comes in and it uses the Rule 404 language, just says we want to use this for motive or intent. And that's the problem here, because, oh, and then I'll also say that later in the week, the defendant then did file a motion to exclude. The motion does look like it kind of encompasses all of this. However, the motion had already been allowed for the government. So it would have been nicer had trial counsel objected. The issue, though, here is because this is so difficult to keep out, you're finding, and I think you're going to see more and more defense attorneys not viewing this as something that, or as a matter of course, they're just going to allow this stuff in, and that's my concern.
Well, I mean, so that's not anything we can do anything about.
No,
I mean,
but
we're in a substantial risk land because the question is whether it creates a substantial risk because there was no objection, right?
Right, and let me talk about substantial risk, because I think we can get there, and I don't think you need any new cases. You don't need to set any sort of precedence here, but what you do need to do is, and I'll point you to two cases, Crichton, number one, and Yell, which is an appeals court case, and that's actually cited in the defense motion on page 45 of the motion. I usually cite that, I think it is in my brief, but this is actually the common law standard of how you get this sort of bad act evidence in, and it's a very high standard. And at least in 1985, and as has been quoted a number of times, here the crime which the defendant was charged would not be rendered unintelligible. That's the language, unintelligible if the references to the defendant's prior conduct or whatever bad act it is omitted.
Right, but so I mean if you could distinguish. First of all, Commonwealth v. King, and secondly, McDonough, this notion that there is a common pattern of conduct and that this oral sex comes in a series of escalating events which are increasingly invasive or serious sexual assaults. Yeah. And it seems that theory of relevance is permitted by the precedent, King and McDonough, and fits the fact pattern here.
I will say that the cases from this court and the SJC kind of go both ways. Sometimes the appeals court and the SJC kind of pulls the reins back, and a lot of times they just kind of go. So I just want to reiterate the SJC, this is from the common law, but again, I think Justice Devins really understood, and I want to just reemphasize this, such evidence compels the defendant to meet charges of which the indictment gives him no information, and it confuses the jury. And in these types of cases, it can often inflame the jury, and that's the problem here. It's not that it's dissimilar.
Wait, sorry, can I want to make sure I understand analytically where we are in the framework. I think that is relevant maybe to more prejudicial than probative, what you're talking about. But I feel as though you've just skipped my question in the first step, which is, especially since we're in substantial risk of miscarriage of justice, and there was no objection, whether this is relevant. I think it's relevant. I'm not sure if you have an opinion, if you've expressed an opinion on whether it's relevant to establish a course of conduct.
And
if not, why not?
It's a slippery slope is the problem. And what I'd like to do is draw from the Seventh Circuit language, and hopefully this will answer your question, and you can tell me if it doesn't. But I'm just quoting from U.S. versus Gomez. This is on page 52 of the brief. A common misconception about Rule 404 is that it establishes a rule of exclusion subject to certain exceptions. That's not quite right. The text of the rule does not say that propensity evidence is inadmissible except when used to prove motive, opportunity, intent, etc. Rather, it says that propensity evidence or other act evidence is offered to prove a person's character, inviting the inference that he acted in conformity therewith is categorically inadmissible. In other words, whenever the jury, it's less about what the court can prove or what the government is looking to prove, and it's much more about is the jury being invited to draw that propensity? If the jury is being invited to, then it needs to be excluded. And that
Mr. Benyon, you're the defense, and I realize you weren't trial counsel, so I don't mean to say you are, but the defendant's defense at trial was that she made it up and that she had some financial motives to do so, right?
Yes.
And so I know they're older cases, but the Commonwealth cites both Hanlon and I think it's pronounced Chartier to talk about, and I'll reframe Justice Wood's suggestion in a minute. This continuous course of sexual exploitation was what the language talks about, and I think what Justice Wood was somewhat describing. So I understand your argument, but we have to tether each case to its facts. And the cases that you cite, and we have certainly, and the SJC has overturned convictions on prior bad act, uncharged conduct evidence, but here, the amount of the evidence compared to some of those other cases was minimal, and it is tethered as part of this course of sexual exploitation. So tell me why Hanlon and Chartier don't apply here, or that you have a different case that's this kind of a case, not the global cases, because you and I have had conversations about prior bad acts before. Tether it to these facts as opposed to the theory. I understand your theory and your overall concern about this evidence coming in. I share that with you. But we've got to do it case by case. So I need your help on this case. Tether it to this case.
So in this case, it's not necessarily a course of conduct. All we have is one blip here.
Right.
That's just it. So you have the testimony of the two young women, and that does set out a course of conduct, but you have, it's not like a whole bunch of courses of conduct, uncharged courses of conduct are bringing in to kind of paint this picture.
Sorry, I'm not, sorry, go ahead.
No,
It's
that's
not-
my point. If you could answer my question. It's one act as part of a chain of events that explain this conduct, particularly where he says she's lying. She has a financial incentive to make this up. That's what I need your help with.
So yes, the problem here, and I'm not trying to go, global on the issue here, but when you have a course of conduct, and this one here is so close in time to the indecent assault and battery that is the problem, because a jury can then see that. They know it's not charged. They have the indictments in front of them. It can do a couple of things. It can inflame the jury, but it doesn't paint conduct. It's just one extra thing that the government can kind of pile on to this defendant.
I'm not following that. I'm looking at it differently, I guess. My conception is that there are a series of escalating acts that the defendant engages in, and this is one chain in that escalating link of acts. And so, in other words, it sounds like you're conceptualizing this act itself to be admissible under the course of conduct. The act itself has to be a course of conduct. That's not my conception at all. My conception is it relevant to establish a course of conduct? In this case, an escalating series of events. Are you saying that that's wrong?
I understand how you're looking at this. I'm not saying it's wrong, but I'm trying to show you that, and I guess maybe the framework of what underlies your question, and I know you've asked me this a couple of times, I was hoping that quote could kind of set this up that I read.
I've read it, by the way. I read your whole brief.
Thank you. The cases talk about how prejudicial this type of stuff comes in. And when you have an indecent assault and battery right next to an uncharged act of oral penetration, it is not only inviting this propensity evidence, in other words, I guess, let me try this. Take that uncharged act out. How much more or less does it really affect the government's case? And that gets back to the Yell idea of, does the government's case just fall apart, or is it unintelligible? And in this case, it doesn't, because the victim was able to testify as to the whole course of conduct.
Well, sorry, I don't mean to cut you off, but it sounds like you just undermined your own argument. Because, of course, you have to, especially in the context of substantial risk of miscarriage of justice, it sounds like you're saying if you remove this one uncharged act, the rest of their case stands on its own, doesn't fall apart. It sounds to me like you're saying it was not a harmful error. It was not prejudicial. It did not create a substantial risk of a miscarriage of justice to add this.
It does create a substantial risk of miscarriage of justice. I'm not saying the government's argument falls apart, but what they're arguing, the way they're setting it up, still makes sense to the jury with respect to what the government is alleging.
Okay.
And it still has to be based on whether the jury believes the defendant, or I'm sorry, the victim, the alleged victim's testimony.
How does your argument change at all, if at all, based on the couple of acquittals here?
I don't think it does, because again,
Doesn't it show that the jury was able to sift through?
not necessarily, because again, what we have here is certainly the indecent assault and battery. I mean,
Right, it was not guilty on on one of the indecents and on the posing, right?
right, but the indecent in this case, the one that was so close in time to the uncharged bad act did stand. And so I think the other one just didn't have any evidence to support it. And that was one of the problems. In this case, this type of evidence does inflame the passions of the jury. The worry is that if they understand that the oral issue is not indicted, are they more likely to want to convict on the indecent assault and battery just to make sure that the defendant doesn't escape?
The uncharged act is not more inflammatory than the charged act of anal rape, right? So
It's not more
it's not
inflammatory?
more inflammatory than the conduct that underlies the rape conviction. Would you agree with that?
You're talking about the anal rape yeah.
Yes. So help me then understand how the admission of this uncharged conduct created a substantial risk of a miscarriage of justice when you have a course of conduct that culminates with the act of anal rape, which seems to me to be more equally as serious as the uncharged conduct.
So again, I hate to draw the picture back again, but the issue here is that the jury is supposed to focus in on the evidence and make sure that each element is supportable. When you, and I understand the fact that the girls testified, and I'm not raising a sufficiency issue here. I understand that cases like Santos show that evidence is more than enough, but I think that shows why this type of pre-jury deliberation evidence that comes in can be so problematic. There's nothing I can do absent polling the jurors, did you find this prejudicial? Was it really prejudicial? We're just kind of stuck with, hopefully, courts drawing a bright line so that, courts don't step over it. In this case, I think it can be stepped over, or I think the court did step over, did cause a substantial risk of miscarriage of justice, only because the government's case rested just basically on the testimony of the girls. They got to testify, the jury got to believe them, but when you throw in that uncharged bad act, you just don't know how lay jurors are going to react to that. The fact that we're also talking about an anal rape, which he was convicted of, points to the fact that propensity, we want to make sure that propensity really doesn't enter into this. If the jury just even thinks, and that's why I kind of come back to, if the jury is even being invited to make that propensity, that's when the courts need to really step in and say no, and there's just no good reason for an attorney to not object, file a motion, and just try to keep this out.
Let me see if the panel has any other questions. Seeing none, we're going to have to leave it there. Thank you very much, Mr. Mannion. Can they call? Just a minute. Can they call? Okay. Thank you. Attorney Conkey, when you're ready.
Good morning, may it please the court. Lindsay Conkey with Trial ADA, Allison Portney joining me at council table. asking this court to affirm the defendant's convictions. As an initial point, my brother raises this as a 404B issue, and that was certainly one of the ways that it was raised in the motion in limine, but that's not how the motion judge determined that this was admissible evidence. And so I'll point to you in the appendix, we have the docket, there's an entry from July 15th, where he said, after hearing and as explained on the record, motion is allowed. In trial prep, victim recounted as additional fact penetration. It is not a separate bad act.
Sorry, what's the record site? Did you have a record site?
Yeah, the record appendix, page 12. It's just on the docket. He didn't write it on there. It's July 15th, I believe. And so I am happy to explain to this court why, even if he had not made that determination, that it could have come in under 404B. But as an initial matter, we would need to decide here that he abused his discretion in saying that this came in as not a separate bad act.
Sorry, I'm trying to unpack this. So July 15th, an endorsement on the motion. So there's no transcript of this, right?
No, there probably is. I do not have that transcript in front of me. I only have the actual jury ones, and I'd be happy to provide that transcript to the court after.
So what does this mean? In trial prep, victim recounted as additional fact penetration. It is not a separate bad act.
Right. What does that in terms? So the judge determined that this was part of the same episode. So this wasn't a separate bad act.
Sorry, I'm confused. The bad act I thought we were talking about is the oral sex behind the dollar store or Dollar Tree.
Yes.
And that was connected to the charged act of the defendant making the child touch his penis.
Right.
Right. Then there's a separate charged rape charge, which involves penetration.
Correct.
That's why I'm confused. This oral sex allegation I thought was not connected to penetration, but was connected to the touching with the penis.
That is correct.
Okay.
It was one Dollar Tree event. My guess is that the motion judge in writing penetration was referring to the oral sex because there was no additional penetration. So my guess is that instead of saying oral sex,
Okay.
he referred to it as penetration.
Okay. I mean, I understand. Okay, that's helpful. I understand, but I'm not. Okay. So I understand that they were essentially all one act. I mean,
Yes.
happening pretty
Exactly.
quickly. One certainly res gestae is a thing that people say, and I'm not really sure what they mean, but I think what they mean is if this all happened quickly in sequence,
Exactly.
then it's all really one thing, one episode.
Exactly.
That's what you're saying.
Yes, and that is
Okay.
what the motion judge correctly found. And so
Okay.
that is why this evidence was able to come in. He
I'm
didn't
sorry,
even-
now I'm confused. So it's related to which charge conduct?
So I believe it's
happened
indictment 4. So there's only one Dollar Tree event that is being discussed. And so the charged conduct was the victim touching the penis, but the uncharged act was then the oral sex. But they all occurred in the same event, in the same car, on the same night, between the defendant and the victim. So this was not a separate bad act in the sense that it happened outside of the Dollar Tree parking lot on a different day.
Just to help you, I think you misspoke. The touching with his penis, according to the indictment, is 5, charge 5.
Okay, thank you,
Right.
yeah, right.
Okay, so this is the oral sex is in the same event as charge 5, touching the penis behind the Dollar Tree for which he was convicted.
Correct.
Right, okay.
And the indictment and the jury slip are very clear in specifically what conduct is being charged and what the jury is deciding on.
Right.
And so if you look at the jury slip on page 59 of the appendix, it's very clear that it says KJ touching penis. I
Right.
think that's the exact quote, but.
Thank you, that's helpful. But I just want to preliminarily, is it fair to say that this was a pure credibility contest? And if not, why not?
Yes, between whether the defendant and the victim, yes, a credibility contest
right.
between the two of them.
Okay,
Yes.
all right. And this, when it came in, there was no objection. I think we've all agreed on that. There was no limiting instruction.
Correct.
Okay, either at the time it came in or in closing, in final instructions, right?
So in fact, when the Commonwealth brought the motion to eliminate, they requested a limiting instruction and the defendant declined it.
Okay,
Yes,
yeah.
the defendant specifically
right.
declined a limiting instruction. That being said, in his jury instructions, the trial judge did discuss briefly that you could consider, I believe, I'd have to look at the transcript exactly, but did discuss in general, the bringing in, other events and things like that. But no, the defendant declined the instruction and did not object at trial to the evidence coming in.
All right, well, that's certainly relevant. The prosecutor in closing argument did rely on this, did make reference to this episode of oral sex, right? Okay. But again, okay, so, all right, thanks. Those are my questions. Thank you.
So I will say just, even if you were to decide that the motion judge abused his discretion, this still comes in under 404B, where it clearly shows the defendant's intent and his pattern. Looking across all of the conduct, there's this exchange of rewards or money or the marijuana or something almost immediately before or after the defendant sexually assaults the victim. And so this is another instance that leads to that. So here it was the jar of pickles. She really liked pickles. So it comes in under that, under the intent, the pattern, and it helps give context to their whole relationship.
I understand and I appreciate that you made the point that's very important, that the Commonwealth was trying to do the right thing here and saying, we request a limiting instruction to bring this in. So it's not on the Commonwealth, I get that. But given that the judge, and do you think there's a problem with the judge, I guess, not giving a limiting instruction, creating the danger that the jury uses this as improper propensity evidence?
No, I don't. And that is because the challenge testimony that's now being challenged didn't prejudice the defense at all, because it was entirely consistent with the defendant's theory. His position was that the victim was fabricating everything. And so this additional detail is not introducing like a new or conflicting narrative. It's just strengthening it. It's giving the jury more things to determine whether they find the victim credible or not. So there's no reasonable likelihood that this testimony materially influenced the verdict, because the additional detail gave the jury more for them to assess, as opposed to less for them to assess. I would also just like to touch on the first complaint witness. My brother's argument essentially improperly attempts to add an objectivity requirement that Massachusetts case law does not require. There's nothing in King that says someone needs to be neutral or unbiased. In fact, the court routinely allows parents of victims to testify as the first complaint witness. And I can't think of somebody who would be more unneutral than a parent of somebody who's been sexually assaulted. And again, there was no objection. The Commonwealth, in a motion in limine, informed the defendant who the first complaint witness would be. He similarly did not object at that stage or at trial. So we are again in a substantial risk of a miscarriage of justice. And they simply don't have that here. There's very limited times when you would bring in a substitute first complaint witness, and that's typically for more practical reasons, such as unavailability or incompetency. And that is not the case here with the first complaint witness.
So not to go backwards, but I think the reason I was so confused about the charges is I was under the impression that this dollar store incident occurred earlier.
Prior to the anal rape, yes.
Right. But you're saying it's connected to count 5, which is indecent assault and battery on someone over 14.
Yes.
And that's what was confusing me. So how come some of them are under 14, some of them are over 14?
So I think, and there is actually it's in the transcript as well. So they amended the indictments because initially the dates she was less clear about the dates, and so then they amended.
Oh, I'm sorry?
Less clear about the dates of when it happened, because this happened when she was 11, 12, and the trial wasn't until she was 18. And so she wasn't able to give specific dates, and so they ended up amending them as she was able to pinpoint it.
He was convicted of 1 under 14, right?
Correct.
Okay.
I'm not, so what is the question is, why was this one not under 14? I apologize, I would have to, I can look through the record again, and I'm happy to submit something to
No,
clarify.
I mean, I'm not sure it's relevant, it's just that's what was confusing me about the timeline.
I don't see any additional questions. Happy to take the rest of your argument on your brief.
Thank you, yes.
Thank you both. The case is under advisement. Just want to check with the panel. Do you want to do anything? Is everybody here on the DCF case yet? Yeah. Attorney Scotty has arrived? Okay. Our next case is Commonwealth versus Kelly Torres, docket number 25P745. Mr. Maddox, good morning.
Good morning, Your Honors. My name is John Maddox for the defendant, Kelly Torres. Section 99B4 of the wiretap statute prohibits secretly recording someone, but under the Jackson case, a recording is not secret if the subject has actual knowledge based on objective indicators in the record.
I'm sorry, can I, I hate to change the order of your argument, but I see that as putting the cart before the horse, and maybe you can help me understand why this is what you want to talk about is relevant. It seems to me that there is ample evidence that your client drove recklessly, the only crime she was convicted of, at the moment the officer stopped her. And if that specifically, driving across 3 lanes of traffic repeatedly, taking a mile to stop after the officer activated his lights, and finally stopping in the right lane of traffic, not the breakdown lane. Unless I'm wrong about that, I don't understand how anything that happens from the moment the officer approaches the car could possibly be relevant, strike that, could possibly be prejudicial to the point of harmless error. Help me understand what I'm getting wrong.
She's adding information at that point.
Sure, but if it's unnecessary, if it's harmless error, because what the officer witnessed up to that point is clearly more than sufficient to establish reckless driving, why does it matter?
Well, just the other evidence as to the reckless driving is that the dog was jumping around in the car. There's
right, and
there's
if
that
we all,
possibility that...
Sure, except that she's going on for miles. And so it seems that at some point in that span, she could have slowed down and pulled over to get control of her dog. Mm-hmm. It seems inexplicable and frankly inexcusable that she would, as the officer testified, she would go on for miles doing this, speeding, changing lanes.
Part of the facts of the case, Your Honor, is that she was going over the Braga Bridge. There's no place to pull over. She pulled over after that bridge. So that is why she did that part of it, at least her version of the events.
You didn't make a prejudice argument in your brief as to the argument about her statements that I saw.
I'm suggesting that the comments could contribute to whether could be used as to the credibility of the officer. So you have his testimony, plus you have the video of what he was stating at the scene, so that is a better assessment of credibility. That relates to prejudice. It goes to the judge's determination as fact finder as to credibility. So I'm suggesting that there's prejudice in that respect, if you want to. To answer your question. Okay. Also, in regard to suppression as the remedy, I distinguish this case from the Morris case, where there was a standard practice of notice. Here, there was not a standard practice of notice in the state police policy. In regard to that, there was only a recommendation. So I'm suggesting that even though suppression was unnecessary in the Morris case, where the behavior to be corrected was already being done, here that's not the case. So I'm suggesting, in regard to suppression, that suppression is in regard to the remedy, suppression is the correct remedy, unlike Morris.
Let's talk about Commonwealth versus Rainey then, because Justice Wentland, essentially the holding in that case, right, is that the body-worn camera was not used as an investigative tool, let's leave that part aside, to secretly eavesdrop on an otherwise private conversation. How is what happened at the roadside after a motor vehicle stop that Justice Wood just described to us a private conversation?
Okay, that's discussed on the Commonwealth versus Dew, page 479 in the text.
Well, you cited, interestingly enough, you cited the appeals court decision in that case, and the SJC reversed us in part in that case. So what
No, no, Your Honor.
do?
Your Honor,
They reversed us in part.
Your Honor, the holding in SJC was as to remedy. They did not touch the merits. So the merits are still good law, Your
Maybe if I can
Honor.
finish my question, we'll be on the same page, because I don't think we are right now. The portions of due from the appeals court that you cited, my question is that still good law in your view based on the SJC holding?
Yes, Your Honor, it's good law and it's controlling law.
Okay.
And it's my argument. I mean, the distinction between Rainey in this case is that, as pointed out in due on page 479, is that in Rainey, it was non-investigated because it was a victim. Here, they are targeting a suspect. That's the language on page 479 in due. So this is a classic plain vanilla targeting a suspect. This is somebody that Trooper Pacheco observed, you know, engaging in the crime of negligent operation according to his testimony. So that is plainly and clearly distinguishable from the Rainey situation. Also, I'd like to point out that's an argument made for the first time on appeal. It's waived as well as being necessarily incorrect.
Oh, but we're allowed to look at the case law. I have Rainey in my hand right now.
Well, it's wrong, too.
Rainey's wrong?
No. The argument that the Commonwealth is relying on Rainey is wrong. This is not a non-investigative scenario.
Right, I said put that aside, because I understand it's a roadside stop. So I'm trying to understand how to apply Rainey in this context when Rainey speaks to the question of an otherwise private conversation. And Rainey does a very extensive discussion about how we are to look at not just the statute, but the preamble and the legislative intent. And it's ironic to me that, and these are layman's terms, but there was sort of this public outcry in our state and I think across the country about police should be wearing body cameras, and now the police are wearing body cameras, and your client is now complaining that the use of the body camera violates the Massachusetts wiretap statute. It's a little ironic to me. So I'm trying to understand, how do we take the preamble, the statute, and the legislative intent, and how does that fit into your argument?
Well, a couple of things. I mean, in the preamble, it says the use of such devices should be limited to investigations of organized crime. That goes against the Commonwealth here. That there would need to be actual knowledge on the part of the defendant. In any event, the Jackson case in 76, I mean, half a century ago, answered your question by saying that the language in 99B4 means that there has to be actual knowledge on the part of the subject. So that is the law. That is controlling law here.
All right, but I want to, in Rainey, when discussing the Gordon case, the SJC says, we acknowledge that subsection 99C could, quote, be read literally as making unlawful the audio taping of booking procedures without the knowledge of the person being booked. Substitute in there the audio taping of a roadside stop.
No,
We're unwilling to attribute such an intent to the legislature in the absence of more specific language. Instead, we read 99 in the context of the statute as a whole, including its codified preamble. The legislative focus of the wiretap statute was on the protection of rights and the deterrence of interference by law enforcement. The legislature did not appear to have in mind the recording of purely administrative booking steps following an individual's arrest. We declined to read the statute as barring the admission. Why is this case, why are the facts here different? This is exactly what the legislature intended, the recording of a roadside stop to protect, in this case, the citizen and the police officer from what did or didn't happen.
Okay, an administrative procedure is not targeting a suspect. It's an administrative procedure. All roadside stops are not the same. Sometimes you're targeting a suspect, as in this case. She was seen committing the crime of negligent operation. That's targeting a suspect. You can have instances where a roadside stop is not targeting a suspect and would be like Rainey, where it's similar to a victim, or the administrative case that you just cited. I can give you an example. If a roadside stop where the cop sees a taillight out, pulls the person over, that is a civil infraction. He's not targeting a suspect. Another example, an officer.
Let me pause you, right? Because she was also found responsible of speeding in a Mark Lane's violation. So arguably, we don't know yet, has she committed the crime of negligent, is there probable cause for negligent operation? Is this a Mark Lane speeding case? How do we know that at the time Pacheco pulls her over?
Well, I would suggest that based on his observations, I mean, he described the incident. If you listen to the body-worn camera, he says, you could have killed somebody. You're weaving from the left-hand lane to the right-hand lane, from the Jersey barrier to the guardrail 6 or 7 times. That's not just a Mark Lane violation. That's a different piece of conduct.
And so, sorry, your theory, I'm still struggling. I'm still stuck on the materiality. So the theory is that he just said that on the body-worn camera footage. And there's a reasonable possibility that what she then says will convince a fact finder that the police officer was lying in his characterization of what just happened.
Yes. What she said on the body-worn camera was that her actions were attributable to her blind dog jumping from the back seat to the front seat, and she was trying to pull over, but she couldn't because the bridge was there. That's a different version of events. That's a matter of credibility.
She didn't say, I wasn't weaving from
He doesn't deny it, right.
All 3 lanes. Right.
She's attributing it to the dog as opposed to element 3, the negligence element of negligent operation. She's blaming the dog.
Okay.
So
that's her statement.
In Ashley, we said that what matters for purposes of the wiretap statute is whether the recording was investigative.
I'm sorry, I didn't
Whether
hear
the
you.
recording itself was investigative. So an interrogation, which was what was at issue in Ashley, is plainly investigative, okay? And we said that doesn't matter for purposes of the wiretap statute. The interrogation is investigative, but the recording of it was not. Why doesn't the same thing apply here?
Sorry, I don't have a clear answer for you, Your Honor. I'm suggesting that this is investigatory in nature and that the
recording is not.
was part of that.
In Ashley, the defendant tried to draw a distinction with the booking, was it Gordon, the booking video? So, and we rejected that distinction, saying even though the interrogation itself is investigative, the recording is not.
Well, the recording in the Dew case was considered investigatory. I'm relying on Dew and footnote 16 of Dew. I'm suggesting that Dew has a contrary result as to what you're suggesting. That was the undercover buy, cell phone held down, the body-worn camera stuff was
That's the recording is investigative in that situation, right?
as it is here.
Why? I'm not understanding.
Because it's monitoring observations of inculpatory statements.
Isn't it the same thing as a recording of an interrogation police station?
That would be, well, I'm not sure if that would fall towards, I guess it would, but I'm relying on Dew, Your Honor.
We have to overrule Ashley in order to find in your favor here, right?
I'm not sure what the distinction between Dew and Ashley would be. I don't know. I'm relying on Dew, page 479. If I could move briefly on to my second issue. I know this is an issue that the appeals court rejected in Santos. This is an old-fashioned Bryant Factor 2 argument where the police had probable cause to arrest, therefore the witness should be deemed to be in custody for Miranda purposes. I'm suggesting that that's not entirely replaced by Groom Factor 2, where the officer tells the person that they're a suspect. I'm suggesting that that isn't the entire universe of possibilities, because under Massachusetts law, going back to the 1800s, a person is deemed to know the law. There's no exception for Bryant Factor 2, so they would be deemed to know that the police had probable cause to arrest her for negligent operation. Therefore, that would contribute to a determination of custody under Bryant, and Groom factors as a matter of Massachusetts common law and Article 12, even though the argument doesn't work for the Fourth Amendment. That's been rejected. It was also rejected in Santos. The FAR denied the ruling. I just want to keep it available so that I can stick it in an FAR and maybe catch somebody's attention someday. Unless there are any other questions, I'd like to rely on my brief.
I don't see any. Thank you very
Thank
much,
you, Your
Attorney Maddox. Attorney Sanchez.
Good morning. May it please the court. Alicia Sanchez for the Commonwealth.
So I have a question. Are we bound by Judge Gobern's findings in terms of his rationale on the wiretap issue?
I think when reviewing the motion to suppress, you're bound to his subsidiary findings of fact, absent clear error, but you review independently his findings and conclusion of law. So I don't think you're bound by his rationale of the wiretap statute.
So when he says, well, he says, I don't think there was any due process violation. I think the best practice they should notify. I don't think that falls under the wiretap statute, and for those reasons, the motion to suppress the images is denied. But he talks about, I'm trying to find it, I apologize, what he thought she knew or didn't know with respect to the red light. Are we bound by that?
We're not bound by that because, you're not bound by that because I think in the evidence in that motion to suppress hearing, there's exhibits 1A, 1B, 1C. The photos, which you can review de novo, and in those photos, the colored photographs, you see that the red light is on. And so here in that case, in this situation, he properly denied the motion to suppress the statements made, captured by the body-worn police cameras, because the Massachusetts wiretap statute does not apply here. In reading Gordon and Rainey, we look to the preamble and of the statute, and a common sense application of the intent of the legislature would not require us to find that this was a violation based on the body-worn cameras being public-facing cameras meant to capture the incident and to enhance public trust in the police.
When we assess whether the error was, or if there was error, harmless beyond a reasonable doubt, do we consider the judge's explanation of his guilty finding?
Of his guilty finding. I'm sorry.
The reason why he found the defendant guilty of negligent operation but not of the OUI. Do we consider what he said at the end of the trial?
At the end of the trial, he said, what can you remind me? What?
He says, I credit the testimony of the troopers that you were from one side of the road to the other. And I didn't see anything on the video. I mean, do we consider that in determining whether the error was I keep saying error, if there was error, harmless beyond a reasonable doubt?
Well, I don't think, I'm trying to place this where in each of these arguments, but where he found, well, first of all, it was an error to deny the motion to suppress, period.
I understand. Assuming there was error, we have to determine whether it was harmless beyond a reasonable doubt, right? And
Yes.
whether it would have affected the judge's findings of guilty or not.
Yeah.
In answering that question, do we consider what he said at the end of the trial?
I don't think we would consider what he said at the end of the trial, where the evidence was sufficient to support, there was so much ample evidence of negligent operation. And you're saying he credited, I'm sorry, I can't wrap my head around this one.
Certainly you were driving negligently. I didn't
Yes.
see anything in the video there, but I certainly credit the testimony of the troopers that you were from one side of the road to the other. Unfortunately, they didn't give you a chance to fully explain. First of all, you shouldn't have had the dog in the car, and then he goes on about the dog.
Yeah, okay, I'm sorry, I had to place myself back to where that was. Yes, so he says clearly, you didn't have a chance to explain that the dog was jumping back and forth in your car, but you were driving negligently. I don't think you need to credit that, his findings of that, because really, the question is whether a person in the situation, a reasonable person would have, how they would have driven if a dog were jumping back and forth in the car, and a reasonable person would have pulled to the side of the road and stopped and not proceeded for over a mile. If that makes sense. Going on to the second motion to suppress, that also was properly denied. There's a case, Commonwealth v. Caw, that discusses Miranda warnings aren't required for a general on-scene questioning incident to a routine traffic stop. And I go on to say how the groom factors, there's nothing here that changes the circumstances from a non-custodial situation to custodial. And going to sufficiency.
Which case did you just say?
Commonwealth v. Caw, it's K.A., and it's 70 Massachusetts Appeals Court 137.
I don't see it in your brief.
Yes, it's not in my brief. I found that after. Apologies for that. I kind of more so focused on going through the groom factors in my brief, but I should have just pointed you to Commonwealth v.
70
Caw.
Mass Appeals Court 137?
Yes.
Do you think that the appeals court decision in due is still good law?
So, no, not on the appeals court decision. The SJC in 2024, I believe, decided that in due, where the police were secretly recording the defendant doing drug deals, that was a violation of the wiretap statute, and he would have needed a warrant to do that. And so I don't believe that the appeals court decision is still good law. I would rely on the SJC 2024 due. And as to sufficiency, I'll just briefly touch on that. There was ample evidence of that the defendant was driving in a negligent manner, where she was driving through multiple lanes, she was speeding, she almost hit the guardrail, she almost hit the median, and this went on for over a mile. And again, the judge was, entitled to reject her explanation of the dog situation. It's really, what would a reasonable person do in that situation? And they would have pulled over.
Could I return to my question? Let me try to ask it a different way.
Yes.
Okay. The defendant argues that any error in the admission of the video was not harmless beyond a reasonable doubt because in the video, the defendant made statements about having had drinks at the casino, and that could have factored in to the conviction of negligent operation, which as a general matter is true, right? So even if someone's not guilty of OUI, a fact finder could still consider evidence of drinking as part of negligent operation.
Yes.
Okay? Do we consider what the judge said, which he seemed to be saying, I'm finding you guilty of negligent operation because I credit the trooper's testimony about you going all the way across the highway a few times.
Yes.
Do we take that, do we consider that in determining whether it was harmless error, or do we consider more generally whether the statements about the drinks on the video could have contributed to the guilty finding?
I think it would be more generally, right?
So we do consider whether the statements about the drinks would have contributed to a guilty finding.
So if it were error, she does say, yes, I had one drink. And if it were error, I think you would have to factor in about wondering about prejudice, but really there's no prejudicial error here that would where there was so much ample evidence of neg-op, the weaving of going in and out of lanes, the almost hitting the guardrails. And she had glassy eyes. She also had a slight odor of an alcoholic drink. So that when I had a drink would not have caused such prejudice, is what I'm trying to say. I'm sorry.
No, that's all right.
Trying to wrap my mind around going back to what was said.
I don't see any other additional questions.
All right, thank you.
Thank you very much. The case is under advisement. Let me just check with the panel. Do you want to do a break or go?
I can
Do you want a break or go? Chief, can we do one more case? Are you good to do the last case without taking a break? Just want to make sure. Okay. So we're going to hear the last case that's scheduled for today's list. This is Department of Children and Families and Another versus Mother and Another, docket 25P310. The case is fully impounded, so counsel, no names, please. And I believe that the department and child's counsel are splitting the time. The department 8 minutes and the child 7 minutes. Is that correct? Yes, Your Honor. All right, and everybody's here? Okay. Just a minute, Ms. Heisman. I just want to make sure everybody's at council table. You may proceed.
Good morning. May it please the court, Lynn Eisenman on behalf of Mother. Your Honor, his mother is asking that you reverse the trial court's order approving his adoption by his foster parents. Unless the panel has any specific questions for me, I would like to address the preliminary, or the injunction, I should not call it preliminary, the injunction that the court issued.
Isn't it moot?
I don't believe it is, Your Honor, because so the order was clear that the department was not supposed to increase visitation or change it in any way from what was in effect at the time. One of the most central issues to the judge's ultimate approval of the adoption plan was that there was a so-called lack of relationship or familiarity between the aunt and uncle and the child. The department was trying to develop that relationship between the child and his maternal relatives, but was prohibited from doing that because of the injunction. And so I think it had a direct impact on the judge's ultimate conclusion. And it was the department wanted to increase those visits, but was prohibited from doing so.
If it's not technically moot, how do you respond to the child's argument that it's waived? Because it does seem like the judge initially issued the injunction pending the conclusion of the Douglas hearing, and then that hearing was delayed for quite some time unexpectedly, and nobody moved in the meantime to lift the injunction, seek reconsideration. So why doesn't that constitute waiver?
So I think that was similar to what happened in McKnight, where in that case the judge issued an injunction giving the department specific terms that they had to meet in order to come back in to modify the injunction. The terms of this injunction were clear that it was in effect until the end of the hearing, and understanding, of course, that there was a mistrial.
Right, so after the mistrial,
Correct.
The mother could have asked then, right?
She could have. So the mistrial was in February of 2024. The injunction, I think it was the end of February, so the injunction had been in place since the beginning of June of 2023. Moving at that time to modify the injunction, I want to say that the damage had already been done. That was such a long time where this relationship could have been developed.
Also, this was not the mother's motion. This was DCF's. Well, it was the child's motion having, I guess, gotten wind of DCF's plan to do this. So, if anything, it seems to me DCF should have moved to alter this injunction.
Right, and it was issued. Obviously, mother has no ability to control the visits that DCF is offering to the maternal relative. So it was issued against DCF I'm not sure that mother really would have had standing to be able to move to modify it. I didn't address that issue, but it was issued against DCF. It was clear that who it affected. Mother and DCF were aligned in their position, certainly.
I know this is, I'm just thinking out loud, which is always very dangerous, but I'm wondering under Rashida 1 and 2, with what the SJC says folks need to do in the lower court, does this fall under reasonable efforts, abuse of discretion kind of? I hear what you're saying about did mother really have standing, but I think there was a collateral way to get at this because it was impacting her.
Right, so I guess I go back to the language of the order was clear that it was going to be in effect, and everybody, all the parties knew that this was an issue. So Child's Counsel files the motion. The first motion that gets filed, not heard right away, was for a finding of abuse of discretion. The second motion for the injunction gets filed and heard a couple, 3 weeks later. That issue was squarely before the court, the issue of visitation with the maternal relatives. The court made an order about it. So it wasn't, I think, necessarily like Rashida contemplates where, you know, this is kind of on the back burner, nobody's brought it to the court's attention. It was front and center.
You don't think the injunction ended by its terms when the mistrial was declared? Because it reads to me as an injunction pending the conclusion of the hearing.
Right.
So when the mistrial was declared, why wouldn't then the injunction have lifted? Or at a minimum, the mother could have asked for reconsideration or filed some sort of motion, motion for clarification.
So I think, well, the case did not go to judgment, right? When the mistrial was declared, the case didn't go to judgment, so it's still open.
I agree, but the hearing was concluded at that point until a new one commenced several months later, right?
Right. So the injunction itself, the last sentence says that the department is enjoined, and then until the court has heard all of the available evidence and decided which plan is in the child's best interest. So I think while that so-called first Douglas hearing was mistried, the court had not yet made a determination about approving one plan over the other. So,
well, the last sentence says, accordingly, the department is enjoined until this court has heard all of the available evidence and decided which plan is in the child's best interest. So that you're saying that's not until
I'm saying
decides the competing plan case.
Correct, until the so-called second Douglas hearing is concluded and the order issues.
And more, but the standard for this injunction in the first place is that the moving party, the child's lawyer, I guess, has to demonstrate a risk of irremediable harm. And so I guess the theory was, although I didn't see it, that expanding visitation from 1 hour to 3 hours a week was going to create a risk of irremediable harm. And so it's not clear to me how that danger, if that's what the court thought that there was, would have abated with the declaration of a mistrial. In other words, if that's the basis for your injunction, that danger hasn't gone away because we've had a mistrial.
Correct.
Right.
Right. I have to presume from reading the transcripts in the motion hearing that that's, in the face of the order, that's what the court was concerned about.
Right. And this was, I think, in your brief, that this ruling puts a thumb on the scale in the entire Douglas hearing process.
Correct.
Right. And that's your position, right?
Correct.
Yeah.
Yes. And that the court, so two kind of main branches of that is that, one, the court, if we're just looking at an injunction, did not apply the legal standard of irreparable harm, so, et cetera. And so we don't, the order on its face is erroneous as a matter of law because the legal standard was not applied.
There was not a demonstration of irremediable harm by expanding visitation from 1 hour to 3 hours a week.
Correct, because the motion gets filed on June 2nd. It's filed, served, and heard all on the same day with a short order of notice. The hearing, it was not an evidentiary hearing, so the judge took no evidence, did not hear from the social worker,
Hearing on the motion for an injunction.
Correct.
Right.
Yes, I should clarify. So the first Douglas hearing started about a month prior, so she had direct testimony from the expert. Cross had not concluded at that point. But that expert was really talking about the plan, not so much visitation, and I understand that she did observe one visit. So there was some discussion of that, but it wasn't the focus of that hearing. Be that as it may, at the motion hearing on the injunction, nobody from DCF was called by child's counsel, who I submit had the burden because they were alleging abuse of discretion and seeking the injunction. No exhibits were offered into or admitted into evidence. The only thing before the court at that point in time was the expert's CV from the hearing in May. So I don't think it has to be remanded for further findings because, quite frankly, at that point in time, there was nothing before the court to support that order. And then from there, that set the tone for the rest of the case. In addition to the injunction piece, we have the Isaac and Jeremy pathway that, DCF had permanent custody of this child at the time that this injunction was issued. And by statute, they had the power to control visits with the child, certainly subject to a finding of abuse of discretion. But one of the things that the court was required to consider is whether DCF complied with their regulations and whether they're supporting a relationship between the child and kin. That's per their regulations. So this was something that DCF was actually trying to comply with both the statute and their regulations and was prohibited from doing so because of the injunction.
Can you speak to the question of prejudice? So the child argues that the visit still continued, albeit not for 3 hours.
Correct.
And there was no increase in attachment during those 17 months of visits. And so it's speculative to say that increased visits would have changed the outcome. How do you respond to that?
So the aunt and uncle were only visiting, it was every 2 weeks for 2 hours, and
Well, that's later, right? They asked for it.
correct,
asked for
and
that,
that
right?
it was
Okay.
that was the same amount of time. It was just a different structure as opposed to weekly for 1 hour. It was every other week for 2 hours to accommodate physical location. But I think it's speculative the other way too, because the theme, one of the themes of the judge's findings is that there is no relationship, and they can't build a relationship with the child if they're not seeing him more frequently. And so I think that's the prejudice, is that you can't conduct, the court can't conduct an even-handed assessment of the competing plans when the court is prohibiting there being a relationship in the first place, or a sufficient relationship, I should say, between the proposed placement and the child in the first place.
Well, the judge also relied on the fact that the aunt and uncle did not have any contact with the mother or the child for the first 2 years, and relied pretty heavily on that, and from that concluded that they weren't really interested in the child as a person, and really they're motivated by loyalty to the aunts, the grandmother. So how do you respond to that?
So for the beginning of the case, the goal was reunification between the child and his mother, even though she was a minor. And so I think, family can step back because they want that reunification to happen. So when DCF did change the goal to adoption in April of 2022, then that started the process of that family coming forward. And it was within 5 or 6 months, I believe, that letters went out to family, to kin, to try to recruit them. They made their intentions known that they were willing to adopt this child. filled out their application to adopt, went through the home study process. And so from there, it did develop at that point. So while they were not necessarily involved, while the goal was reunification, once it became adoption and really people knew what path that the case was going down, they did come forward. So unless there are any other questions, I would again ask that this court reverse the order.
I don't
Thank you
see
very
any.
much.
Thank you very much. Next, we're going to hear from the department, and that is for 8 minutes. Good morning. It's still morning. Good morning.
Good morning. Members of the panel, may it please the court. My name is Caitlin Bertino for the Department of Children and Families, and I'm here today asking you to affirm the decree issued by the lower court.
I'm sorry to jump on you right away. I really apologize for being rude. But this is unusual in my limited experience because the department below was advocating for the aunt, I know great aunt, but aunt to be the kinship placement here. That's right. Am I right about that?
Correct. The department.
And you didn't, and that wasn't willy-nilly, yet you were working with Bridges Homeward, a recognized agency designed to figure these things out, did your due diligence, did a home study of the aunt's house, and after all of that work concluded that the aunt was the appropriate placement here, right?
Yes, we did.
Okay, and then that carried all the way through the end of the Douglas hearing, right?
Yes.
You didn't shift your position until after the judge made her finding, right?
Correct.
Okay, and so why are you switching your position now?
We're not switching our position. The judge here has wide discretion in determining between adoption plans, and for us, it wasn't an abuse of discretion, and it wasn't an error of law for her to choose the child's plan in this case. Both plans were viable. They had, the child had choice for loving potential adoptive parents, but after listening to 11 days of testimony, both the foster parents, the aunt, the grandmother, and mother, and reviewing all of the evidence, the judge determined that the child's plan was in his best interest.
So focusing on this, page 27 of the judge's order, I mean, there are a lot of things to talk about, but the judge seems to conclude that the aunt and uncle responses were demonstrative of their lack of credibility and lack of insight into the challenges of parenthood. Now, I recognize that's the summary as opposed to the findings of fact, but I'm curious about the department's view about that, given the aunt's and uncle's clear track record of success as parents. They had raised 3 children together, the oldest a college graduate, the youngest, the second at UMass Lowell at the time, and the third in doing well in high school, all having a relationship with all of their children. I'm wondering what the department's view of the reliability of that conclusion and its importance to the overall finding was.
Well, the analysis is based off of the best interest of this child, not aunt's other children. And after listening to aunt's testimony about how she viewed this child as her blood and wanted the family to be together, the expert's opinion that aunt was not able to communicate with the child, didn't follow his cues, didn't have the correct response to different play. I think it's reasonable for the court to conclude that to this child, they were unsatisfactory parents.
Right. So initially, both you and your partner organization, Bridges Homeward, placed great emphasis, I think it's fair to say, and tell me if it's not fair to say, on the cultural heritage link.
Yes.
And so I read the aunt's testimony very carefully at the Douglas hearing, and it seems to me, first of all, she had great sophistication about the process of a child becoming bilingual because her own children had gone through this process. Her youngest had, at the same age as child here, come to the United States, did not speak English, and she watched that child with firsthand knowledge, firsthand observation, become bilingual. And so here, where we've already talked about the injunction, and I don't want to go through it again, she has very limited opportunity to help this child become bilingual. And so the knock, as you just mentioned, the primary knock is a lack of bonding with this child. It seems to me, does that, again, to the department in deciding, well, you know, we think the judge didn't abuse her discretion. Is that troubling to the department?
So first, adoption of Irene tells us that a cultural match is the aim, but it's not required, and it's a factor among many. And it wasn't just that its great aunt was unable to communicate to the child. I think the judge even says in the transcript, I'm not concerned about the Spanish and the English. It's more that she was unable to explain fully to the court's satisfaction how she would overcome those barriers with this child. And during the expert testified that not just with language, but with play, she was unable to respond to certain cues. And I would also say that bond wasn't the only thing that this court considered. Another big issue, or I guess knock against great aunt, was that the court found that aunt would just be a nominal caretaker to this child. The aunt could not satisfy to the court in her testimony why there were any safety concerns around mother or grandmother.
So can I stop
Sure.
you there? On that point, I spent a lot of time on that point. I go to page 54 of volume 10. Virtually my entire page is underlined and in red and highlighted to indicate how important I think this is. To me, I'm mystified. It seems that the judge, the aunt is testifying to the exact opposite. The aunt is saying she will not allow the mother and the grandmother to be alone with the child. She's explaining that she understands very clearly as a mother of three that this is her responsibility, her sole responsibility. And so, and then I understand you're going to say this is a credibility contest between the judge and the judge is evaluating credibility. I just want to make sure I'm understanding. The testimony physically, what's happening in the courtroom is she's testifying in Spanish, and an interpreter is testifying in English. Mm-hmm. So the judge's task is to listen to the testimony of the interpreter and determine the aunt's credibility. That's the exercise, right?
Correct.
Okay, and the judge found that what she said was just not credible. Even though it was a good answer, it was just not true.
She found that it wasn't credible in light of all of the other evidence. Mother testified that she would be over to the house every single day helping the child get ready for school, that she planned to appear after school to help him transition home from school. And I think importantly, the judge wasn't satisfied with the aunt's explanation as to why the child was in care in the first place and why there could be a supervision required. She knew, I think, maybe that the child had to be supervised, but she couldn't explain why the child had to be supervised, and so the judge wasn't satisfied with her answer.
Okay, just to clarify one point.
Sure.
The mother, I think you said, the mother testified she'd be over there every day. The mother is a teenager, and it's not up to her, it's up to the aunt, and the aunt said, didn't credit that, the aunt was not saying that was what was going to happen.
Correct.
Okay.
So the judge found that, based on her assessment of the aunt, that she didn't see the child as an individual with specific needs. Does this child have any specific needs?
So this child was born substance exposed. So the expert testified that he has a heightened risk for behavioral issues, for developmental problems. At this point, it seems to be a healthy child. I don't believe he has an IEP. I think that was not true. The foster mother...
He doesn't have any special needs, right?
At this point, he just has an increased risk for special needs, but he doesn't have any special needs right now that we know of.
And he was evaluated for an IEP,
Correct.
And the evaluator, presumably a professional psychologist, concluded he did not need an IEP.
Correct.
Right.
We're going to have to leave it there. Thank you.
Thank you.
Counsel for the child?
May it please the court, my name is Christina Scotti, and I am representing the Kelly child in the case before us. I I have answers to Justice Wood and Justice Shin, but hopefully, as I continue, hopefully they'll be answered. If not, please stop me at any point. So to me, this is a simple case of two competing plans after mother stipulated to her current and future unfitness, and her rights were subsequently terminated in 2022, October. At issue right now is whether or not the trial judge is abusing her discretion or abused her discretion by approving my client's proposed permanency plan of adoption by his adoptive parents over mother's and DCF's plan of adoption by a great maternal aunt and uncle at the first Douglas hearing, of which there were two because of significant unforeseen delays, that I'd like to make very clear that the judge at the time had no way of knowing. This was June. This was June of 2023, and it wasn't until, let me continue. The first Douglas hearing began on March 10th, 2023. The injunction, and I know I won't speak much on that, but that was asked for at the beginning of June. To just kind of counter my sister's argument, the judge felt as though it seemed that it would be tipping the scales in the alternate direction by giving the maternal great aunt and uncle more time. As a Catholic trial attorney, you usually see progress and more bonding occurs. That's when more visitation happens. And that was not necessarily illustrated in any of the dictation that I saw. So for that reason.
I mean, we don't have to spend a lot of time on this, but the standard is irreparable harm if they did that. There's a difference between we didn't yet have bonding and if you give them more time, there will be irreparable harm.
Understood. I think to the judge's point of view, and it was understood that it was going to be concluded at the end of June 2023, that this would get figured out, and that she just didn't want to tip the scales in one way or another. Again, the court, because of extended delays due to lawyer changes, the mistrial was February 29th, 2024, which is, June 2023, February 29th, 2024, that's an extremely long amount of time, and I would argue that at any point, the mother's counsel, the department could have come back in, and I actually respectfully disagree that you would have to wait till the end of a Douglas hearing. At any point where you see that there's going to be significant delays, you can go in and at least ask and have it be on the record.
The judge thought that the Douglas hearing would end within a couple months, then how would it tip the scales the other way? What's the reasonable possibility it would have tipped the scales the other way? A month or
I
two
think
of
maybe to leave it
additional
status
visits.
quo as to see
Right.
where things...
That's really what it seems to boil down to, but what's the authority that the judge has just to maintain status quo?
Again, it would just be up to her discretion, and...
Wouldn't she have to rely on the standard for a preliminary injunction? Is that not the standard that would apply?
I believe it is the standard. To me, it was a bit jarring at first glance, but then I did realize that they had an ample amount of time to revisit this, and nobody did, very suspiciously, if that really was an issue. Moreover, again, this is an extremely difficult case. I say this with so much compassion and grace because it's a child having a child. These are not facts that anyone likes to look at.
I know time is short. I'm trying to get to the ultimate finding by the judge, and well aware that the judge has discretion here. Finding of fact 151 seems to be one of the more important ones. Aunt lacks insight into the safety issues presented by grandmother and mother's parental deficiencies. And in fact, on page volume 55, the court asks Aunt a question. So what's the reason again that you would not allow them to care for him alone? Answer, because that would be my responsibility. I'm a mother who has children, and I'm always on top of everything that my children are doing. And I think that needs to be understood against the backdrop of she's a very successful mother who has successfully raised 3 children, one of whom's graduated college, and I've been through this. So I'm struggling to understand. I mean, I know the standard's high. The judge has seen her in person, albeit through an interpreter. And I guess you're going to say this is not one of those rare cases where the judge's finding is clearly erroneous. But what do you say to that one? Why is that not a good answer?
I mean, again, respectfully to the judge, I would go to my sister's point of view where she says that to her, that was her interpretation. I also have read everything that you have read, but obviously in her findings, she felt, and I think this is very important, being that the judge, again, we're deferring to her, felt like the alternate plan was a ruse. This is the idea, that it really...
You sent me something in the record that supports this inference that this is a ruse. I scoured the record for this. I cannot find any evidence that this is a ruse. This is a woman who has got 3 kids who she successfully raised herself. Where's the evidence of the ruse?
Again, I think it might be in the fact that just that the mother said she would if, again, as to your point, if allowed, because again, it's under maternal great aunt, come over, help. I mean, yes, for 2 years, and it is true that she was not part of the case for 2 years. The mother did not know the great aunt's surname. Whether or not she knew the great uncle very well, that's besides the point.
The mother was a child. The mother is, well, at the time, is still a child, right?
I'm very well aware.
Right. But so my point, I'm not being compelled by anything the child has said. And I think nobody's compelled by anything the child has said. She's in an impossible situation,
Agreed.
And we all hope the best for her. But I'm looking at what the aunt said. What the aunt said, I find no evidence of a ruse.
Again, I mean, I also looked through all the findings, and I looked through the summary, and I was told that was her conclusion. I was looking for specific finding numbers to give to you, of which I cannot give to you. But I do think that, I mean, I've visited the child now twice. There is, and again, it's not just attachment, but in terms of just special needs, when I first met with him, he was not speaking.
Counsel, unfortunately, your time has expired, so we're going to have to leave it there.
Okay.
Thank you very much. Difficult case, very well argued. The matter is under advisement. That concludes this session of the Appeals Court. I'd like to thank the court staff, particularly the clerk's office, and our excellent timekeeper, law clerks, and court officers. We are in recess.
All right.